How are you feeling about the Flowers decision?
Well, I'm pleased, but not entirely surprised, based on what I read about the argument. It seemed as if there were 5, maybe 6 justices that were going the way of Curtis Flowers. How about you?
Well, as a defense attorney and someone who cares about racial justice, I am relieved and elated. I didn't know with this court where we were going to end up, but I'm happy with this outcome.
We are both lifelong, diehard, career indigent criminal defense lawyers. So let's be upfront about that. We're also law professors who know a little something about the law of jury selection.
And we've both written about the peremptory challenge and Batson.
We have. We've both written about it from different perspectives. Yours from a criminal procedure perspective and mine from a legal ethics perspective. So we bring that to the table as well. And we both combined have tried too many jury trials to count. So we're here to discuss the Curtis Flowers case. Let me offer a little background on the case. This was a murder case that happened in the small town of Winona, Mississippi, population 5,000. 4 people in a furniture store were murdered. Can you explain a little bit, Vida? Like, there were 6 trials. That's rather extraordinary. 1 prosecutor, and what the outcome was of those previous trials and why?
Sure, it's a remarkable case. There were, in the first 3 trials, Mr. Flowers was convicted in each one of those trials, and there were no black jurors sitting on the trial. This took place in a small town in Mississippi. Mr. Flowers is black. 3 of the 4 victims were white, and the prosecutor who prosecuted all 6 trials was also white. He managed to get black jurors off of the first 3 trials. The 4th and 5th trial had some black jurors on it, and those trials hung, and mistrials were declared. So when there were black jurors, this wasn't an easy conviction. And in the 6th trial, the prosecutor was able to use 5 out of his 6 peremptory strikes to exclude black jurors from the trial.
He apparently let the first African-American prospective juror remain on the jury and struck everybody else. This is a small town, I should point out. It's 5,000 residents. It's a relatively small prosecutor's office with 4 or 5 full-time prosecutors, all white men. And I should also point out that Curtis Flowers has maintained his innocence throughout these many years and many trials.
And the demographics of the county are important. 53% of the county is African American, and so the fact that there were no African American jurors in the first 3 trials is really troubling.
The cases in turn were reversed for pretty much the same sets of reasons. Either the discriminatory exercise of peremptory challenges, which are challenges striking prospective jurors for no reason at all, but they're not supposed to be exercised for race-based reasons, and prosecutorial misconduct in general. The cases went up to the Mississippi Supreme Court a couple of times and went up to the U.S. Supreme Court before as well. This was the 6th trial, the case that was just decided today by the U.S. Supreme Court, and the argument, the issue in the 6th case was the prosecutor's racially discriminatory exercise of peremptory challenges.
During this jury selection process, there are 2 types of ways that jurors can be excluded. One is for cause, and that's when a juror reveals that he or she can't be fair for some reason. Maybe he knows the victims, maybe he's friends with the defense attorney, maybe he refuses to apply the presumption of innocence. And there are an unlimited number of for-cause strikes. And either side can ask the judge to strike a juror for cause.
And that's because the jury has to be fair and impartial. A defendant has the right, as a matter of due process, to have a fair and impartial juror judge his or her case. Sorry, go ahead.
No, perfect. And the other kind of strike is the peremptory challenge, and that was what was at issue in the Flowers case. A peremptory strike is a strike for any reason. A juror can be struck by either the defense or the prosecutor for any reason, and the sides get an equal number of strikes in most jurisdictions. In a case called Batson in 1986, the Supreme Court held that race could not be one of the reasons that a prospective juror was struck by a prosecutor. And that case was decided both because of the constitutional rights of the defendant as well as the rights of the prospective jurors. And subsequent cases to Batson have extended the premise to defense attorneys and to gender as well.
What were some of the highlights in the opinion for you, especially in the majority opinion by Kavanaugh?
Sure. Well, I think what I think you and I know as defense attorneys is that Batson has widely been thought of as a failure because it doesn't really get at discrimination during jury selection for a couple of reasons. One, it's really hard to get into the mind of a prosecutor and to know what he's thinking. Another reason is that defense attorneys and judges don't want to call another professional who they see every day in the same courthouse. They don't want to call him a racist or say that he was exercising his peremptory challenges in a way that was racially discriminatory. And then there's a couple of other reasons that I think Batson has been a failure, and that's that the court requires that or allows a prosecutor to come up with a race-neutral reason.
One of my favorite pretextual reasons for striking an African-American jury was in a case where the prosecutor maintained that the prospective juror had a mustache, and that was suspicious.
What's nice about this decision is that it puts some teeth, or at least tries to put some teeth back into Batson, and that's by doing comparative juror analysis, where we look at which jurors were allowed to stay on the jury who were white, and whether they're similarly situated to excluded jurors, and the allegedly race-neutral reasons that were given to exclude them. So in this case, one of the reasons that the prosecutor gave for excluding one of the black jurors is that he knew the Flowers family, or that she knew the Flowers family, but there were 3 white jurors who were seated who also knew the Flowers family.
And there were no questions asked of those white jurors. There were on average 29 questions asked of each African-American prospective juror, and on average 1 question asked of white people. And even those white people who had some connection to the parties in the case, the store where the murder took place, and the family of Mr. Flowers, no questions were asked of those prospective jurors.
And so the issue in the case was whether the fact that the prosecutor was able to offer some race-neutral reasons, did his conduct, when you look at the entirety of the history of the case, did it violate Batson? And the court found that it did.
And the court paid special attention to the history of the case, and the historical record showed that the state, that is Doug Evans, tried to strike all black prospective jurors over the course of the first 4 trials, a total of 41 of 42 black prospective jurors, and again, there was no data as to the 5th trial, and then he did the same exact thing in the 6th trial so that there was a clear pattern.
And when you think about what he has cost Mississippians, it's really troubling too. I mean, this is one of the poorest states in the country, and yet he doggedly has pursued this prosecution, prosecuting 6, and I won't be surprised if there's a 7th trial as well.
But I also think raises all kinds of questions, some ethical. When does a prosecutor no longer act as a minister of justice, which is what prosecutors are supposed to be according to the rules of professional conduct, and become a prosecutorial zealot?
And I think, prosecutors are supposed to represent the entire community. So they should feel okay about that same community being on the jury and not just focus on particular groups. And it's troubling when they don't.
It is troubling. I was heartened by Kavanaugh's opinion, that it was Kavanaugh who wrote it, that he seemed to truly understand the history of exclusion of black people from juries in this country, which goes way back, and which through all kinds of methods. There was resistance to the seating of black people on juries in this country. He seems to get that. He seems to get that it's persisted now, and that prosecutors are a chief violator of the principle of equal justice under law. I was heartened by that.
I thought it was great that he took the time to spell it out so that the reader would understand that history. So what do you think should happen going forward?
Well, I endorse the idea that we should end peremptory challenges for prosecutors for a number of reasons. They've consistently abused that right, and it's just easy to demonstrate. Now, it was especially easy in this case. So when the justices say, oh, this was an extraordinary case, this is a once-in-a-lifetime case, words to that effect is what Justice Alito said in his concurring opinion. First of all, it's not an extraordinary case. It's not a once-in-a-lifetime. This happens every single day in courtrooms across the country. This meaning the exclusion of prospective black jurors from serving as juries in criminal cases. Prosecutors have avoided and resisted Batson for as long as it's been in effect. I was a Philadelphia public defender in the beginning of my career, and Philadelphia is the place that brought a very famous training video to light that had been used in 1987, in which an assistant district attorney in Philadelphia, a guy named Jack McMahon, was training young prosecutors on how to avoid and subvert Batson. How to use a code to remind yourself of the race of the jurors and so on. And that's why I remain skeptical. That's why I think after a case like this, there are going to be some prosecutors, and this was Philadelphia, it's not the Deep South. Again, this happens all over the country. I worry that, prosecutors who, are a little too zealous will do what they can to subvert by training prosecutors how to avoid, number one, the prima facie case of racial discrimination in jury selection, and number two, how to offer race-neutral reasons that will get them, out of the objection.
One thing I was thinking might be helpful is for us to give our thoughts for defense attorneys, what they can do in light of this decision, or keeping this decision in mind during jury selection. And one thing that comes to mind for me is for defense attorneys to be brave, to actually make Batson challenges, because I think a lot of times they're worried about it. They're worried about offending the prosecutor who they may have future cases with. They're worried about not getting a plea offer that's good for their next client, but they have to do it for the individual client. And so I think that's important. And making a record about the demographics of the jury. I don't know if you have other thoughts.
No, I think that's great. I wish we could come up with a bullet point list of things to include in a training of defense lawyers. And I love your idea of emboldening lawyers to just make the challenge. Why shouldn't defense lawyers routinely make a Batson challenge? It's an objection. And that's what defense lawyers do, is we make objections when there's something improper that's happening in a trial, and then let the government make its case. I think also training folks about these other clever pretextual ways to work around Batson and now to work around Flowers, to be mindful of disparate questioning. I think probably more challenges ought to be made to the veneer in places that are much more racially diverse than the veneer, that is the panel from which prospective jurors will be chosen, doesn't reflect that. I think in too many places, you get nearly all white or overwhelmingly white veneers in places that have many more African American and Latino, Latinx jurors. Other things to train them on?
I think your point about disparate questioning is a good thing for defense attorneys to be thinking about and taking notes about during jury selection. If you notice there are two similarly situated jurors that have the same answers to a certain question, but only one of them gets questioned in depth or rigorously about it. That's something to keep notes on.
That's great.
And make a record on.
And I think we could do better training in general about jury selection. My favorite work that's come out is by the Colorado Public Defender's Office There's a method that they employ called the Colorado method of jury selection, which focuses more on cause challenges and tries to get the judge ultimately to make the decision after a good, well-trained defense lawyer, through a series of questions, uncover some of the implicit unconscious bias that jurors often have. I mean, jurors like to think of themselves as fair-minded too. We all do. That's the problem of implicit and unconscious bias, is that people are not going to volunteer that they have that bias. It can only get surfaced through questions that, if you believe in the Colorado method of jury selection, include basically embracing a person and encouraging them to share some of the misgivings they have that reflect a certain amount of bias.
And if you're a good prosecutor, you'd avoid peremptory challenges altogether. You'd give them up.
Yes, I couldn't agree more. If you are a progressive, enlightened prosecutor who believes in the evidence in your case, I mean, this is our pitch together. Don't exercise them. Believe in your case. That's the honorable thing to do. Try your case. You should be able to try your case in front of an all African American jury. Why shouldn't you?
And if you want the trust of your community, this is the thing to do.